regular business meeting of the Putnam County Board of Commissioners. We're happy that you're here. We got a large crowd, and we've still got a few seats. I see folks still coming in. And so we thank you for being here. You are welcome. And I will call this meeting to order at 10:02. First item on the agenda is the approval of the agenda. And I would call for a motion to approve the agenda.
So moved, Mr. Chairman.
Is there a second?
Right.
Second. We have a motion and a second to approve the agenda. Any further discussion? Hearing none, we'll call for the question and vote electronically, please. Voting is complete. Districts 1, 2, 3, and 4 vote aye. The agenda is approved. Next on the agenda is our invocation, and I'm extremely happy to introduce Robin Bennett from the First Baptist Church. Robin was my Sunday school teacher and a terrific lady. And Robin, if you could come forward with our devotion.
Honorable Commissioners, thank you very much for this opportunity. And if everyone would please bow their heads and pray with me. Dear Lord, we want to thank you, Lord, for the blessings you have given us, especially as residents of this beautiful county. You have provided us with a jewel in the midst of this great state. Let us always remember, as you tell us in Jeremiah's letter to those in Babylon, seek the peace and prosperity of the place to which I have carried you. Pray to the Lord for it, because if it prospers, you too will prosper. We do so pray, Lord, that we prosper and that you are always in our midst. We pray as well that each of these men that lead, guide, and direct our county will first be led, guided, and directed by you, that they will be obedient to you. Remind these leaders to always put on your armor so they may make their stand against any evil schemes. Let them stand firm in truth, in righteousness, and readiness. Let them also stand firm against baseless criticism as they sacrifice their time for our county. But let them always be receptive to constructive critiques and to the whisper of your Spirit. We know that every kingdom or county divided against itself cannot stand. So we pray against divisiveness, but that in spite of our differences, we will all work together for the greatest good for our county. Let us always remember to come to you first. Let us each commit to pray for our county and those that we have asked to lead us. We pray for wisdom and for a long lens to view decisions by. We pray for your protection from harm, violence, and discord, and that your will be done. And we pray all these things in your Son's holy and precious name. Amen.
Amen. Thank you, Robin. We appreciate you being here. And now, if I could get everyone to stand and move your hats. And Commissioner McElhaney is going to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thanks, Don. We'll move along to our regular business meeting. And first is public comments. I will ask for the sheet for public comments. And let's see, this is for number 15. Okay, Facebook number 15, okay. Before we do public comments, I'm going to ask our attorney to talk about the rules, the regulations, whatever you want to call them. What do you call them?
Whatever you'll tell me to. No, I appreciate it, Mr. Chairman. The chairman had asked me to go over the ordinances regarding public participation. We don't normally have this many people here, so it's probably good to remind everybody what the rules are, as well as the commissioners as well. So under section 2-42, public participation in meetings of the Board of Commissioners shall be permitted in accordance with the provisions of this section. Excuse me, I'm fighting a cold. Under subsection A, the board may allow public comments on agenda items and any non-agenda items, except personnel. Individuals desiring to address the Board of Commissioners are required to sign in prior to the commencement of the meeting or public hearing. Such comments by any one person should not exceed 3 minutes. The chairperson shall have the right at any time to stop all public comments when in the chairperson's discretion such input violates the provisions of this section. In addition, or as an alternative to speaking, written materials may be submitted to the board. While the chairperson may recognize board members or staff during public comment, there's no obligation to respond to or address comments made by the members of the public. And specifically, if you have not signed in, the sign-in sheets were over there. I think everybody has signed in. So if you haven't now, we'll give you 30 seconds to run up and sign. Under the decorum ordinance, subsection B, members of the public shall not make inappropriate or offensive comments at a board meeting and are expected to comply with the rules of decorum that are established for commissioners. Individuals violating any rules of this board may be ruled out of order by the chairperson or on an appointed order made by a commissioner. The chairperson will rule an appointed order. An individual vote violating the rules of decorum may be removed from the meeting at the direction of the chairperson. To the commissioners and the public, under section 241 decorum, all commissioners must conduct themselves in a professional and respectful manner. All remarks should be directed to the chairperson and not to individual commissioners, staff, or citizens in attendance. Personal remarks are inappropriate. A commissioner may not speak at a meeting until he or she has been recognized by the chairperson. All comments made by a commissioner shall address the motion that is being discussed. I know there's a lot of public interest in several of the items that are on the agenda tonight or today. I would suggest that we try to keep our comments germane to the topic. I know that a lot of what is on the agenda goes beyond the specific item, but we will do our best as staff to make sure that both the commissioners and the public focus on the specific item that's before the commissioners. And if I do step in and ask you to direct those comments that way, I don't leave anything specific or personal about your comments. I just want to make sure we stay on topic with what actually is before the Board of Commissioners. Thank you, Mr. Chairman.
And thank you very much. Moving along in public comments, we have one person signed in, Barb Bargo, and I didn't understand, but it's Facebook number 15 is what she said she wants to speak on. Do we have anyone to sign in for? I'm sorry, Mark, please.
Barb Bargo, and my comments are going to be on January 3rd, 2025, item number 15 regarding Facebook Live, for all of you to know. First off, it was out of order. When it is proposed to get rid of Facebook Live, it seemed to me that the person talking was attacking the Facebook taxpayer watchdog group of Putnam County, Georgia, naming some of the people who are the admins on that page and are politically activated active, not activated, in the community. Why? That was really out of order. Also, our commissioners are always telling one person that he is misinformed, which is not true. The last meeting, which was January 24th, they said that he was misinformed on an item that we printed out directly from the Board of Elections. Then we find out that they had moved 200 votes from the no to the yes. Why is that? I don't know, but I have to make some phone calls and find out. Now, that we have, okay, we're voting on this person and the public, and I'm just wondering why we keep saying that he is misinformed when everything he does is researched, and as I said, it's printed out for us to see. So, I am really kind of disappointed in this, and also, I am very disappointed in the name calling that I hear from the commissioners to the commissioners. You guys are all put on a very, very high level, and this should not be done. Just let us decide that we are not going to accept this, okay? I've heard it, and I think it's just wrong that everybody would be fighting against each other. You gotta stop. I know this, I've been here, okay? So you got to have respect for each other. I was told long ago that I had to have respect for the people that are up here. And if you guys can't have any respect for yourself, I can't have respect either, all right? And this is the last thing I'm going to do, is I'm going to remind you all of what I've said before. We are all of our own opinions, and we have the right to our opinions, okay? So we will now agree to disagree. Thank you.
Thank you. That is the only person that we have signed up for public comments. And we will move along now to item number 6. That's the consent agenda. I'll make sure nobody signed up. Item 7 and 8 is all people signed up for, looks like. So moving along to the consent agenda, it consists of approval of minutes from the January 3rd, 2025 regular business meeting, approval of minutes from January 24th, 2025 called meeting, approval of minutes from January 29th, 2025 call meeting, and approval of the 2025 alcohol license. And let's see, do we have who signed up on the alcohol license? Usually we put that up, there's a few. I know they were in there because I read them. There they are. And those have all been approved by the sheriff and sent to us for approval. That is the consent agenda. Is there any objections to any of the items on the consent agenda?
Mr. Chairman,
Yes, Commissioner.
I would like to move that we approve the consent agenda with one modification. The minutes as they stand for the call meeting on January 24th, as I've conveyed to the other commissioners and to the county manager and the county clerk, I think don't capture the essence of the discussion around HB 581. And my concern is that when someone reviews those minutes in the future, or someone who didn't have the benefit of attending wouldn't understand why the motion was the way that it was, or why the vote turned out the way that it was. So I would like to add 2 sentences that I can send the county clerk that will address this matter.
Can you say what the 2 sentences
Yes.
are?
Sorry, Mr. Chairman, Commissioner. This is a consent item agenda, so if you'll take that item from the agenda, I know it's parliamentary, but take it from the agenda, vote on the remaining consent agenda items, and then move into this one. So your motion would be to remove January 24th call meetings from the consent agenda.
Okay. I move that we,
Sorry, no motion. If you don't want it on there, it'll be taken off. So, and Mr. Chairman, you will take up the remaining items on the consent agenda with January 24th call meeting minutes taken off.
Okay, the motion, are you making a motion that we remove item B, the approval of minutes January 24th from the consent agenda?
apparently I can't make a motion, but I would like it removed.
But you can make the motion after we.
Okay.
We will address item B next. Okay.
Mr. Chairman, I move we approve the consent agenda with the exception of item number B.
Second.
We have a motion and a second on the floor. The motion is to approve the consent agenda with the exception of item B. Any discussion? We have a motion and a second. Any discussion? Hearing none, I'll ask you to vote electronically on this one. Voting is complete. Districts 1, 2, 3, and 4 vote aye. The consent agenda for item A, C, and D have been approved. Now I bring item B back, and this is approval of the minutes of January 24, 2025, the call meeting. And I'll call on Commissioner to give us his two sentences or whatever.
Yes, I'd like to move that we approve the minutes of the call meeting from January 24th, 2025, with the addition of this sentence. Commissioners Hersey and Garrett made a case to hold public hearings about HB 581, not necessarily with the intention to opt out, but to give the commissioners and citizens the opportunity to further discuss an emergent and multifaceted issue and to ensure that the commissioner's final decision is as informed as possible.
Okay, is there a second to that motion?
Second.
We have a motion and a second. Is there discussion? Hearing none, we'll vote. The motion is to approve the minutes of January 24th call meeting with the addition of a statement as read. And I obviously don't remember that, but you're going to provide that too. Okay? And no discussion, so I'll call for a verbal vote. We'll start with District 4.
Yay.
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 That has been approved. So the motion carries, and we will instruct our clerk to add that statement. Moving right along now, I believe now we're going down to item 7. We have several people signed in. Now bear with me, I only have 3 pages of people signed in. And so I'll have to look. I'm going to read the motion and then I'm going to pull out the 1, 2, 3. I think I have 3 to speak on. Is that correct? Okay, so I'll read the motion and then we'll move forward with it. There are 3 people here that want to speak. This is an appeal by Ann Foster of the Planning and Zoning Commission, decision to grant sideline setback at 407 East Riverbend Drive. When we get started, Ann Foster or her representative will not be timed when they speak. However, all other speakers will get 3 minutes each. Extra time can be granted by a vote of the board, of course. So we'll start off with the Ann Foster is signed up, so she will go first, and we'll be followed by 2 others. So Ann, come forward.
Good morning. Thank you so much for the opportunity to be here. My name is Ann Foster. I live at 409 East Riverbend Drive. The issue at hand is a pool structure that was built on the lot next door to mine. And in the original, this started back in May of 2024. And in the original plan, which is on page 5 of the information I submitted, there is what appears to be a retaining wall that is not attached to this entertainment structure. It's not only a pool, it's a kitchen, a TV area, a very large area. And there is a retaining wall that starts at about 11 foot from my property line. And at the closest point, that wall is 2.8 feet. I literally can stand there and touch it. And we had Ms. Jackson come out back in May, and there's a timeline in the information that we gave you. And she said, well, no, it's a retaining wall, so it's okay. It's fine. There's nothing you can do about it. It's a retaining wall. He said, well, it's awfully close. And she said, can't do anything about it. So later on in August, we were gone for several weeks. And when we came, and you'll see the retaining wall in the photographs. It's, if you go to, well, I can't tell you what page right now. If you see the retaining wall, it's much lower than the side of the pool. Sometime in August, what they did is they went and they actually attached the pool structure to the retaining wall. They raised the retaining wall, they filled it in with dirt. And if you'll also notice on the original plan, which is on page 5, the stairs are not attached to the retaining wall. And sometime during all that, we look on, all of it was attached to the structure. And we had Ms. Jackson come out on several occasions. She kept telling us it was a retaining wall. Well, it's obviously not. And so when they finished this structure, they came and asked for a variance of 3.75 feet back to 11 3/4 feet. And tried to say it's not part of the structure. Well, it is. It's all attached. The stairs are attached to the pool structure. And we just feel like allowing this variance to go through means that anybody who wants to build something too close to the property line, just call was not attached, and now they've filled in stairs and they've attached it to the structure. So we would ask that you require them to take that out and actually move the structure back to the 11 3/4 feet, which we probably would have been okay with originally. They have a walkway that comes down the side, and you have to have a fence around your pool. So if they had asked us, we would have probably said, okay, we don't love it, but we'll be okay with it, because you need to have a fence around it, and your walkway comes down that side. So it would be reasonable to allow them to do that. But on numerous occasions, we asked Lisa Jackson to look at it, and she just kept calling it a retaining wall, and we contend that it's part of the structure because it's attached. So we would ask that you override the zoning board's approval of this and make them take the structure out, except for the retaining wall if they need that for dirt. And what the zoning board allowed them to do, they put all the travertine down. As you can see in those pictures, it's all one flat patio area. And they even said in their letter to the zoning board, well, we really didn't have enough room. So they wanted a larger patio structure. All the zoning board required them to do was to come in and cut out a little bit of the travertine and plant some plants in it. It's still all part of the structure, and all of the structure is anywhere from 2.8 feet to 5 feet to 6 feet, and finally to about 11 feet from our property line. And we would respectfully ask that you not allow them to set the precedent by building something like this, calling it a retaining wall, attaching it all at some point, and then coming back and complaining that it's a hardship. This house was a $2 million home. This pool structure is obviously several $100,000. This was not a financial hardship to do this the right way, and their original plan does not show that retaining wall attached in any way to the stairs or the pool structure. Now it is all one structure, and we would respectfully request that you make them take this back to the 11.75 feet, which is the variance they were given. I'm happy to answer any questions if anybody has any.
Thank you. There's 2 more people to speak.
Okay.
And now I'm going as they signed in, and this is Dan Butler from 407, I believe it's River Bend Drive, East River Bend Drive.
I'm going to yield to Jenny Bass.
Okay, yield. Next is Jenny Bass.
I have copies of my remarks.
You may give them to- You have 3 minutes.
Good morning, Mr. Chairman and Commissioners. My name is Jennifer Bass, and I own the property at 407 East River Bend Drive. Thank you for the opportunity to speak with you this morning. James Walker Jr. and I purchased this property in October of 2023. We continued investment in this property by constructing a pool. The appeal before you this morning challenges the Planning and Zoning Commission's lawful approval of a variance in connection with the location of a small portion of the pool deck adjacent to the pool. So we're talking about the pool deck adjacent to the pool. For the following reasons, we respectfully submit this appeal should be denied. First, there is ample evidence in the record to support the approval of this variance by the Planning and Zoning Board. Chief among this evidence is your professional staff's report, which clearly states this property has significant topographical challenges, exceptionally narrow layout, and a contour on the right side that narrows further toward the lake. End quote. Given the lake contour, slope, and narrowness of the lot, this request meets the conditions stated in section 66-157C1 of the Putnam County Code of Ordinances. These are the conditions that, by law, must be met for the grant of a variance, and staff indicates that they were met. In fact, the staff report indicates this type of variance would normally have just been granted administratively by the director, but because a code complaint had been filed, the director decided to take it before the Planning and Zoning Commission with a recommendation for approval, which, after careful consideration of the evidence, the circumstances, and the requirements of your code, the Planning and Zoning Commission agreed and granted the variance. Georgia law is very clear that a variance approval must be upheld if there is any evidence to support such an approval. Here, based on the staff's report and recommendation of approval and the other evidence contained in the record, the Planning and Zoning Commission approved the variance for a small portion of the pool deck, and we respectfully submit their decision must be upheld and Ms. Foster's appeal denied. Second, while we understand that Ms. Foster disagrees with the Planning and Zoning Commission's decision, her appeal contains no support for the claim that the variance for the pool deck was approved in error, was not based on any evidence, was arbitrary, or was outside the Planning and Zoning Commission's authority. Your code clearly gives the Planning and Zoning Commission the authority to make such decisions. Furthermore, if you look at all the evidence, it is even doubtful that Ms. Foster can see the portion of the deck in question from her property due to the elevation difference in landscaping that we have installed, and thus cannot claim any harm. In addition, though not required to do so by county code.
Thank you. I'll call one time.
Okay.
Would the commissioners like for her to finish her comments? We can do that. I mean, if she's got a little more time, would you like to grant her some more time to finish? We have agreement. You can finish your comments.
Thank you.
Thank you.
Finally, in addition to I'll be brief. Finally, in addition to the weight of the evidence and the legal authority that supports the Planning and Zoning Commission's decision to approve the variance, we ask you to take into consideration the efforts we've made at considerable expense to eliminate or mitigate any issues noted by the county or Ms. Foster since we became aware that extending the pool deck to the existing lawfully approved retaining wall was not permitted by county code. Since that time, and with the involvement of staff, Planning and Zoning staff, and at the request of the Planning and Zoning Commission, we have completely removed all the tile and concrete that previously joined the deck to the retaining wall, thus severing the retaining wall from the pool deck. We have restored the green space in between, where we planted trees, shrubbery, and ground cover, and a substantial investment that will provide a much nicer view and more privacy to the neighbors, should they even be able to see it, to see the variance that we have. In addition, though not required to do so by county code, in an effort to be good neighbors, we've enhanced the appearance of the retaining wall by facing it with an attractive stone and installing evergreen shrubs along the property line. It is important to note that the pool and retaining wall inspections have all passed and the matter has been closed out by the county. Every step of the way since becoming aware of the code issue created by joining the pool deck to the retaining wall, we've been careful to diligently follow all directives by the Planning and Zoning Commission and staff because we want to do our best to be a contributing neighbor in Putnam County. We are investing in our home and in the neighborhood. We have no intention of renting out our home short-term, long-term, or otherwise. Because our plan is only use it as a place to enjoy the beauty of Putnam County and the lake with our family and friends. I should note that to complete the record, we have submitted the materials and evidence originally provided and considered by the Planning and Zoning Commission when they approved the variance, as well as the letter citing the legal authority we referenced earlier, and this standard statement to protect our rights in this state and federal constitutions. We appreciate your patience, your attention, and your thoughtful consideration, and we are, of course, happy to answer any questions.
Thank you.
Mhm.
I believe we're finished because, we'll have the attorney and Lisa Jackson has come in. Gentlemen, I believe that we probably need to, do we need to hear from Lisa or the attorney? Our attorney is available for questions. Lisa's available.
Mr. Chairman, I would like to hear from Lisa.
Lisa, could you come forward and we have a request as to, your conclusions?
Good morning.
Morning.
You got any questions for me?
My apologies. What I would like is your summary of the decision that was made by the Planning and Zoning Commission and just start there and I'll have a follow-up question.
So this issue did start early last year, and the property owners was issued an NOV once they combined the deck with the retaining wall. They asked for, when we went out and we measured with them, in order for them to stay on a straight line, they agreed to everything. They have not opposed to anything that we asked them to do. We told them that they was gonna have to tear it out because, and they indeed connected it together after the fact, and it wasn't supposed to be connected. So we went out with them, they measured it from the property line, and what was obvious was that the property narrowed as it went toward the lake. It creates a pie shape. So in measuring it, what they realized was that if they went on a straight line and cutting that deck out, of course, it was gonna slant the deck almost nearly to the point where there was not gonna be a deck as you went in. It was just gonna be at a very huge angle. So they asked if we would extend the time for the NOV so that they could indeed ask for a variance just on that lower end. They was in favor of tearing it out, but they felt like they needed a variance on that low end. So we did extend the variance, and they went before the Planning and Zoning. The Planning and Zoning Commission members, they went out on the site, they looked at it, and they made a determination that in order for them to meet their setbacks on that lower end, they decided to grant them a variance for the lower end, not the entire deck. They had to cut most of it out, and just on the lower end, they granted them a variance.
Okay, and just to clarify what you're saying is that the nature, the size, the shape of the property where the pool was constructed for this piece of the pool deck to form a reasonable walkway was only possible if this variance was granted.
Right.
And just to clarify that where the pool is located, if it had been located somewhere else, could it have been done differently, or essentially this is the only place it could have been reasonably put?
I would have to evaluate that. I think that it's pretty, either way, I think that, and this is just my opinion, I think that either way, that if they had moved it over just a little bit, they still would have been looking at a variance because of the topography of that lot, the slope, the contour, the shape of the line. I think they still would have needed a variance.
Thank you.
Any other,
Ms. Jackson,
Commissioner Hurst?
how much variance was granted?
Then can you put it up, was it 11 point?
It was 11.75 from the property line,
Mhm.
so it was only 3 and a quarter
Right.
variance granted. Now, in the appeal or in the presentation to the Planning and Zoning Commission the first time, were the parties asked to get together and try to resolve the issue and then come back a second time to actually hear the request?
Yes.
And did they get together?
Well, from in my observation in the meeting, the applicant, she approached Ms. Foster, but she told her that she didn't want to talk to her. And all of the board members heard that and saw that when it happened. She did try to talk to her and to see if they could set up something, and she put her hand up and said that I don't want to talk to you. And so, I guess I can't speak for the board as a whole, but I think that at that point, they decided that they probably should not encourage that they talk because they didn't know what would happen.
And at the second meeting of the Planning and Zoning Commission, I believe the member from the third district, Mr. Jones, made a motion, did he?
He did.
And what was the result of that motion?
I think he made a motion to deny, and I think the motion died, and there was a second motion that was
Because there was not a second to Mr. Jones' motion, and yet he was the third district representative on that board. And the second motion was to approve the variance of 3 1/4 feet.
Yes, sir.
And how was that motion, how did that motion turn out?
They all voted in favor except for Mr. Jones.
Mr. Jones voted no.
That's correct.
Thank you.
Other questions, Jim? Commissioner?
And I'm just trying to clarify the sort of substance of this. I'm no expert on these matters. So the retaining wall, theoretically, if the appeal was granted, it would mean not that the retaining wall would have to move, but the pool structure would have to be somehow more fundamentally disconnected from the retaining wall. And that's essentially what the person appealing is asking for, correct? Not to move the location of the retaining wall,
Right.
simply to her satisfaction, have the pool be more fundamentally disconnected from the retaining wall. Is that accurate?
I think she would have to answer that.
Commissioner, a portion of the pool is actually in the setback.
Right.
So it would be, if you're looking at the structure, regardless of retaining wall or not, that the 15-foot, and in fact, Lynn, if you'll go to, on the meeting packet, I believe it is page, it's in the item. There's a map that will actually show you the location of the easement or the setback.
I think there.
So if you can, we'll make it as small as possible so everybody can see it. If you see on, this isn't the way I want to do this.
Don't move it on the way. That's the setback line. Commissioner. Through there. So it would catch a portion. It would catch a portion of the pool too.
So therefore to even have the pool requires these variances.
Correct. And if I could, just to orient the board, I know you're asking facts, and I don't want to stop you from asking Ms. Jackson the facts, but I've asked Lynn to also provide the legal context in which we find ourselves. Normally variances don't come before this body, they stay at the P&Z level. But if a party appeals, you stand in the position of the Planning Commission. And so I wanted to orient you to section 66-157C1. And C1 is what you as a body have established as the factors on whether or not to grant a variance. So specifically, again, we've made them as small as possible. Um, But those factors in C1A through F, those are the standards that we are, as a body, are to identify and whether or not you're going to grant, deny, or grant with any changes the variance.
Commissioner Wood, I think, didn't we kind of, on these kind of lots, Lisa, here about a year and a half ago, maybe 2 years ago, because of the pie-shaped, I think it was down Caps Lane, if I'm not mistaken, that we approved the variances because of the topography of the lot. And does this kind of fall in the same category as what, we approved about 2 or 3 years ago? About the
Yes,
same thing, isn't it?
yes, it's common for us to approve, staff to make recommendations and for the P and Z to approve, lots when there are, topography issues or shape issues, anything that's related to the lot.
Okay, so this has been done before. It would, the Caps Lane is very similar to what we're looking at now.
Yes.
Okay, thank you. Commissioner Hershey.
Lisa, you keep referring to this wall as a retaining wall. What is it retaining?
It retains dirt.
It just retains dirt, and
The dirt sediment,
dirt between the pool apron and the retaining wall that it's retaining?
it
Was
retains.
there originally dirt there?
Yes, there has always been dirt, but then they went in and they changed the elevation.
Ms. Foster, could you respond to that?
The original plan that they submitted is not what they built. First of all, I didn't say I wouldn't talk to them. I asked her, really don't want to talk about it right this minute because we weren't at the site. But that being said, the original plan that they submitted was within the parameters of the 15-foot setback. After, let me reiterate, they're asking for this variance after they violated all rules. So this was not something that they asked for prior to. And originally, as you can see in the photos, there was a small retaining wall that was just holding back some dirt. Sometime after that is when they connected it all. So this is all after the fact and after everybody had been told this structure was too close. So yes, originally there was a small wall and all there was between it was dirt, and that's when the wall was raised to the pool height and the deck put in. All they were required to do after that, and they covered it all with travertine, all they were required to do after that was to come in and cut out a few feet of travertine. It's all still attached. The stairs are still attached, the wall's attached at the top and at the bottom. It's all still part of the pool structure, not a separate retaining wall as is shown in the original plan. They did not build what was in the original plan. If it wasn't going to fit when they submitted the plan, why not then go back and say, look, we can't make this thing work? They didn't do that. They went on and built whatever they wanted and came back after the fact and said, okay, now we think it's a problem because of the size of the lot. It wasn't the size or shape of the lot when they submitted the original pool plan.
Ms. Jackson, is it, in your opinion, could they retain the pool without the retaining wall?
No, they needed to put the retaining wall in because of the slope of the property, and that protects her property from runoff.
If the retaining wall is retaining the pool, then is it not part of the pool?
The retaining wall is not retaining the pool, the retaining wall is retaining the dirt and the
So
sediment.
if the wall were removed, the pool would be just fine.
If the wall was removed with the pool would be fine, but the property next door would be subject to runoff from that property.
Not if it was planted.
there would still be runoff, Mr. Hersey, because vegetation takes time to grow and to form.
Well, you put up silk fence, don't you? Isn't that required?
You can put a silk fence, but, okay,
The retaining wall picture is on page 8 of what I submitted. You can see the original retaining wall. It's not attached to it. It's just a separate wall. And that's the wall that Lisa told us was okay.
So,
Other questions? Thank you, Lisa, and thank you, Ann. I believe that we may be to a point of motion.
Mr. Chairman, this is an issue that's strictly for District 3, but it does have implications for the other districts as well. And I would like to entertain a motion, or enter a motion. And that motion is to move to grant a 3.25 foot right side variance, being 11.75 feet from the property line at 407 East Riverbend Drive, conditioned on the requirement that a retaining wall and any structures attached to the retaining wall be located within the variance.
We have that in writing. Do we have a second?
Second.
We have a motion and a second. And I'm gonna read this back because I want to make sure I get it right. The motion is to move to grant a 3.25 foot right side variance, being 11.75 feet from the property line at 407 East Riverbend Drive, conditioned on the requirement that a retaining wall and any structures attached to the retaining wall be located within the variance. Does everybody understand that motion? We have let me let you read it.
Mr. Chairman,
Wait, hold on. We've got a motion and a second.
we have a motion.
I'll let get Commissioner McElhaney a second, and I'll recognize you. Okay, once again, Commissioner Hersey.
Again, I think the real point here is that this structure was attached to the pool, and they are now asking for a variance after the fact. And I am perfectly willing, and I believe the Fosters are perfectly willing to grant that variance, but that variance is only 3.25 feet. And that's what they asked for. And Planning and Zoning Commission approved it. I'm willing to approve it. I think Ms. Foster is willing to approve it. The question is that wall is, if it's retaining the pool or a pool structure, it needs to be within that variance. Now, if they want to remove everything between that wall and have it a freestanding wall, that's another question altogether. But as long as it is attached by dirt, grass, trees, whatever, to the pool structure at the same level as the pool structure, it is a retaining wall for the pool structure and needs to be within the variance granted. And this is from the point of view of all of Putnam County. I mean, this is another example of it's easier to get forgiveness than it is to get permission. And I've seen this for over 30 years, time and time again. And it is just, I think we need to not set a further precedent that, oh, you just go ahead and build whatever you want, and then you come back and say, well, it's a hardship to tear it down. Well, it may be a hardship in this case, but it's a hardship caused by the owner. So I think that as long as that is not a freestanding wall, as long as it is attached by whatever means to the pool patio, but it needs to be within the variance granted. Thank you.
Other comments? I'm looking over at our attorney. He has to see the motion.
I'm sorry, but did the gentleman sign in? And why did you not speak before?
I yielded to Jenny. I haven't had my 3 minutes.
You've had your 3 minutes.
Have not.
No, she doesn't.
Well, if you yielded your time to Ms. Bass,
Well, I just wanted to clarify on something you just spoke on.
Commissioner Hershey, point of order, let me confer here. Would anyone like to ask the gentleman a question so he can speak?
no.
I'm happy for the gentleman to speak. And
So I'm the contractor for the retaining wall. The variance by planning and zoning was granted to us based on the disconnection of the wall, which we submitted a plan for that you were just looking at. So we were issued the notice of violation, NOV, work stopped. We went back, redrew, presented that plan to planning and zoning for the disconnection of the pool deck to the wall. We made a mistake by connecting the pool deck to the wall, which was not in the original plan. So we made a plan to fix it, which planning and zoning approved. We disconnected it, fixed it, did everything we said we would do in the conditions of that variance. So we did everything.
And is the wall that is connected by dirt and plants to the pool deck within the variance?
The variance was granted.
The variance, and how much variance was granted?
We
3 1/4 feet.
we removed
3 1/4 feet. Yet that wall that is attached to the pool deck is within 2 1/2 feet of the property line.
I'm
It's
not a
outside
surveyor.
variance granted.
I'm not a surveyor, and neither is Mrs. Foster. We were asked to have a surveyor come out, and we had stakes put on the sideline, which me and Lisa used to measure over.
I can guarantee you that it is outside of the 3 1/4 foot variance granted.
I just wanted to clarify that everything planning and zoning asked us to do for the condition of the variance, we've done and completed. The whole job was permitted, everything's been inspected and approved, and the job is closed.
By virtue of my motion, I'm asking you to do something different. You either have a freestanding wall or it's connected to the pool patio, in which case it needs to be moved within the variance.
The pool patio has been disconnected from the wall.
No, it has not.
From the drawing.
It is still connected by a dirt.
Have you been to the site? Have you visited the site?
I have not visited the site, but I can guarantee you that people who have will verify that it is still connected by a dirt to the pool patio.
Connected via dirt and plants is what planning and zoning approved for the conditions of the variance.
Any other questions?
My motion stands.
yes,
Commissioner Garrett.
Mr. Chairman, I would like Ms. Jackson to come back up and clarify this assertion that the variance granted and where the structure ends are different. Is that accurate?
I think I'm gonna have to use an atom to make a determination because dirt has to be between the wall and whatever the structure is. So by means, in my professional opinion, by means of dirt connecting it, that does not make it a part of the structure. But I will yield to Adam. Adam,
Is it a freestanding wall? I mean, is it a freestanding wall?
yes, sir, it is a freestanding wall.
So if I could orient,
Go ahead.
Commissioner.
Go
I
ahead.
know you're about to solve it, so I'll.
Well, I'm just trying to make sense out of this and use common sense on this. If you got a tree standing up here and a tree standing up here and you got dirt in between it, are the trees connected? I mean, that's common sense, right or wrong. I mean, that's just common sense. If you got a platform here, you got your retaining wall here, and dirt's in between it, it's not connected, in my opinion. Now, if y'all can find a way to make it, see it any different, please let me know.
So Commissioner, if I could maybe orient the body, because I realize that a lot of people came in here for other items today. I want to be mindful of everybody's time. Let's try to get this to a position where you guys can make a decision. To step back for a second. I know there's going to be disagreement among the board members, but staff presently does not consider structures related to retaining walls as part of structures. In other words, with respect to setbacks, fences, paths, retaining walls, our county has not included those as setbacks. In the original plans that were presented, the retaining wall was a retaining wall, and that was the building permit that was issued. The contractor and the landowner did connect that retaining wall to the pool structure, which means it is no longer a retaining wall. It now becomes a part of the structure, which at that point led us to where we are today. That is the reason that it was within the setback. In an attempt to resolve the retaining wall was intended to be separated. Now, whether it is not whether it's separated or not seems to be a point of discussion that I don't think we're going to get to an answer on today. But I will tell you the principle that the planning staff has relied upon is that if it's connected, it's not a retaining wall. It needs to be separate because the retaining wall, imagine it this way, could it be replaced and another one put back as opposed to tearing out the side of the pool? As a result of this conversation, though, it was determined that a portion of the pool structure will still be in the setback. If you look at the purple circle, you'll see the dotted line that starts to the left and comes down, and it turns sort of near the middle of the circle. Yeah, right there, Lynn. That is your setback. So a portion of the pool structure, once it circles and it comes straight down, a portion of the pool structure is within the setback. That was the variance that was granted by the planning commission.
Right.
So the question is, there's really two questions. Do you allow that variance to allow that portion of the pool structure to be within the setback? And with respect to the retaining wall, it is my opinion, and I believe staff would say the same, that the retaining wall, if it is connected to the pool structure, is a part of the pool structure. And by connection, I mean structurally, not sharing dirt. But that is just our interpretation. Obviously, that may not be how all board members agree, but that is the question before the body. And I believe Commissioner Hersey's motion would be to move all structures. The entirety of the structure would have to move left on that picture to where the new setback would be 11 foot and some change from the adjoining property owners. That is the motion before the body. That's the question you would have, and then move on to whatever items would come based on whether or not that motion passes or another one needs to be discussed.
I think,
Mr. Attorney, could you opine on the existence of those stairs, which seems to connect the retaining wall to the pool structure? Is that a connection to the pool?
I think going back to what Commissioner Wooten said, if it's poured concrete, that's a form that goes to the wall, that seems like a structure to me.
Yeah.
If there's not a break.
So that portion of the retaining wall that's connected to the pool deck via those stairs constitutes a connection?
I would have a hard time arguing that it doesn't. Now, we're getting into a little bit of what you do and what the contractor does in response. So if you were to grant a variance, they would still have to comply with whatever terms are granted or not granted. So in other words, if you see the green, it's on the, I think the intention of the green is to serve as the disconnect between the retaining wall and pool structure. If that green were extended down the steps and up, I think we'd have a hard time arguing. I think that is the intended action that would disconnect the two. But until that time, if you grant a variance, we as staff would still have to ensure that they are in compliance with either the code or the variance that gets granted.
And my motion grants a variance of 3¼ feet, but I don't believe that the steps connecting the retaining wall to the pool patio are within that variance. Well, let me come back to, okay, so in order to comply with my motion, the retaining wall would have to be moved inside the variance.
No, my opinion is that it would just need to be completely disconnected from the pool structure down where the stairs are. The stairs would need
So
to
the stairs would need to be removed?
No, the stairs would need to, either, they would have two options. They could, if they want the stairs to be completely connected to the pool, they would need to move the stairs inside of the setback, or they would need to completely disconnect the stairs from the pool structure. If they had to have freestanding stairs.
If I could, Ms. Jackson is stating what the code, how we interpret, the staff interpret the code. Your motion, Commissioner Henry, would actually, I'm trying to think what Henry, I know Henry, yeah, Commissioner Hurst. I told you I'm taking cold medicine. That's not be lawyering. The Commissioner Hurst's motion would actually move all structures. I've got something like that. The Commissioner Hurst's motion would move the entire structure, including the retaining wall. So it's a little, Ms. Jackson was speaking to how we do it. Commissioner Hersey would actually move everything over, assuming 4 or 5 feet.
Commissioner Hersey's motion would need to tear it down and rebuild it, I think. Is that correct? I'm asking.
And just to clarify, tear what down? Just the stairs. Not the entire pool.
Well, I mean, at a minimum, you would have to disconnect the stairs from the pool.
Yeah.
Otherwise, that is a connection between the retaining wall and the pool deck. Is it? Yes? No?
Say that again.
The stairs. Do they constitute a connection between the retaining wall and the pool deck?
Yes, if it's completely connected,
So it is connected.
it would just be a separation. They would have to make a separation.
So you couldn't get to the steps from the pool deck.
It's not
Or
connected.
you would have to just plant Larry oaks there, right?
I'm
Ms.
sorry.
Foster, do you wish to make a further statement?
Well,
Time for a break.
let me say, all they have done to mitigate this is tear up a little travertine and plant some bushes and some ground cover. What's to say, when that dies next spring, they don't just come back and reconnect it all and put pavers there, because there's no separation. Those stairs connect to the retaining wall, and I get that there's dirt, and I understand if they needed a retaining wall. It does slope on that side, and they originally built about a 3 or 4 foot retaining wall going down that side. And you can tell from the pictures, the dirt kind of sloped down. And our assumption was when they did that they would landscape that slope. The next thing we know, they've raised it and made it part of the patio. And even before they finished that, we called again and asked, it's now connected, it shouldn't be connected. The stairs that where they are now were not there in the original plan. They were pushed over and may have been within the setbacks. I'm going to assume if planning and zoning approved the plan that they were within the 15-foot setbacks. But they got moved out and they're now attached. The pool side of the pool is attached to the stairs, which is attached to the retaining wall. Retaining wall is still part of the structure in our opinion. There was room for stairs on the other side going off the deck. That's even where their walkway is going to the lake. Now you come down this side, you come down these stairs, you have to walk in front of the pool to get over to where the original walkway was. All they had to do then would have been to put those stairs in on the other side. But those stairs are now attached to the side wall of the pool, which is attached to the retaining wall, which makes it all one structure in our opinion. And all they were required to do was to cut up a little travertine and plant a few plants. And it's interesting to me that now we're having this discussion about the steps being attached and part of it, because in my original argument with the Planning and Zoning Board was it's attached. The stairs are there, it's part attached. And now it seems like everybody wants to say, well, it is attached, so it's still part. And I couldn't get anybody before to agree to that point, that it made it, by attaching those stairs to both walls, made it part of the original structure, pool structure.
Commissioner McElhaney has asked that you be able to speak. Ms. Vance.
Thank you.
Ms. Vance.
I would like to point out that yes, I would just like to say, we apologize for all of this. We are not asking for forgiveness rather than permission. We are asking for forgiveness for our ignorance because we did not know. But as soon as we did it, we followed every directive of planning and zoning. That Planning and Zoning Commission spent a lot of time thinking about this issue. We tabled it from 1 month to the next. They came out, they visited, we walked through the plan that we submitted. We got approval from them, and their last words to me before I sat down was, you build it to these plans. We don't want any deviations, and that's exactly what we did. And they gave us the approval. We did exactly that. And so, you know, and I think it's a gross mischaracterization to say just that we just pulled up some travertine and stuck a couple of plants in. We completely severed it from the wall. We pulled up all the concrete. We pulled up all the tile. We put in trees and restored the green space that was there. And it is necessary for the pool. It is a structural, and if you took away that green space, the pool, all of the dirt around the pool it would slope towards the borderline, towards the property line. It would be terrible. It would be run off just as Ms. Jackson said. So we have in good faith done everything we can. We took every suggestion. We did everything we can. Everybody's been out. Everybody's approved it as it's been drawn, and the whole matter has been closed out. And I think going back over this with someone who came to the Planning and Zoning Commission, Commissioner Herstein sat next to Ms. Foster during the hearing and had a congenial conversations with during the hearing. I think it's inappropriate to go back and to substitute the judgment of this commission for the Planning and Zoning Commission. And I would remind you of Georgia law, that that the Georgia law is clear on this. You can't substitute your own judgment for planning and zoning.
I'm going to go ahead and call for the question on this
Ms.
motion.
Bass, just to make things clear, I have known the Fosters for 30 years. It's perfectly appropriate for me to say hello to her. She belongs to the same book club as my wife. We have a lot of things in common. To accuse me of being biased because I know them or have known them is just despicable, and I don't appreciate it.
Commissioner Hersey, I have called for the question on your motion. And, we've
Sorry,
talked about, I'm sorry, you, did
Mr.
not-
Chairman,
yes,
are you ending, you calling for?
I call for the question on your motion.
Today?
and debate. Yes,
Well, I'll object, so we'll take a vote on it.
okay. We will take a vote on calling for the question. Do I have a second for calling the question? Second. That does not require a second, I've been told by our attorney. So we'll vote. Do we want to continue discussion or do we want to vote? District 4. District 3? You are
Let's continue discussion.
District 2.
Would like to ask one more question.
District 1. Vote. And I vote to vote. So let's move forward. The voting will count.
Point of information, this is on Commissioner Hersey's motion, not the item. There are additional motions to be made following this item.
And there'll be more discussion. So this is just, we've cut off the question. We are voting on Commissioner Hersey's motion, and I will read it again. It's moved to grant 3.25 foot right side variance, being 11.75 feet from the property line at 407 East River Bend Drive, conditioned on the requirement that a retaining wall and any structure attached to the retaining wall be located within the variance. That's the motion. And we'll do this verbally, I believe. Oh, can we do it electronically? Electronic is up, vote electronically on Commissioner Hersey's motion. We have a tie. Commissioner McElhaney, nay. Commissioner Garrett, yea. Commissioner Hershey, yea. Commissioner Wooten, nay. And Chairman Sharp votes nay. So we will move along for another motion. And the motion that we'll get a motion in a second, is appeal by Ian Foster of planning and zoning decision to grant sideline setbacks at 407 East River Bend Drive. Do I hear that motion to allow the appeal?
Mr. Chairman, I'm not sure what a motion would be.
The motion is to approve the appeal by Ian Foster.
And what is the appeal?
The appeal, I'll read it like it says, appeal.
I understand that, but what is the result?
The results is to grant the sideline setbacks. The results is to allow the setbacks or take away the setbacks that our planning and zoning folks have approved.
Mr. Chairman, if I could, so this matter comes to the Board of Commissioners on appeal. The Planning and Zoning Board voted to grant the variance. Under your ordinances, you have the right to either deny that variance, to affirm it, which would be granted, or place conditions. Commissioner Hersey's last motion was to place conditions. That failed. So you will now need to move forward on either grant, deny, or create other conditions. So in other words, you have not finished the item.
Mr. Attorney, can I just clarify, if we were to vote one way or another today, do both parties still have the right to appeal?
Yeah, the lawyers have made it to where we can be employed forever, so we make the law, right? I can't advise the parties on what position they might be, but the judicial system may go beyond us.
Okay, that's helpful. And my opinion is, and bearing in mind other important items we have on the agenda, I personally don't feel I'm in a position to come to a fully informed decision today. So I would rather than us end up with a divided board and one party feeling aggrieved, I would like to make a motion that we table this. We have a called meeting with the parties to really get the facts on the ground, not delay everyone else here, And this is complicated, and I don't feel like I'm in a position to make a decision.
We have a motion on the floor to table the appeal, and you want to put a date on it? You want to say in the next 2 weeks, or?
It comes back to us.
I would ask for it to come back to us here within a month.
Okay, within 30 days, or before our next meeting, or our meeting in March is what you're saying, I think. I don't know, I mean, but we're, you moved to table the motion.
To our first meeting in March.
Very good, very good. Is there a second?
Second.
We have a motion and a second on the floor. Is there a discussion of tabling? Hearing now, I'll call for the question. We'll vote verbally. If you're in favor of tabling this, signify by saying aye. We'll start with District 1.
Aye.
District 2.
Aye.
District 3.
Aye.
District 4.
Nay.
So the ayes have it. It's 3-1. And therefore, we will table this, and we'll have a discussion sometime between now and the first meeting, which I believe is the 7th of March.
Mr. Chairman, may I
Yes.
request a 5-minute recess?
You may. I kind of agree. We're gonna take a 5-minute recess before we go to 8, because we have, we have 26 people signed in to speak on the next item. So we're going to declare a 2-minute break.
Need that one. You need to go. Need some peppermint. Oh, yeah, I got. Thank you. You want some more peppermint?
It's not. Yes, ma'am. It's not. I'm gonna just end it. I just end it and start back. It's not needed. It's not needed. I just end it and start back. I see it here. Okay, so just let it go. Just let it go.
Turn the mic off. It's fine. I know. I heard you guys.
Wow, crazy. I didn't hear y'all conversation. Order pizza.
I know, right?
We need pizza. We got all the conversation. You want to order it? Pizza? This is on Lynn's credit card. Oh, no.